Hello, everyone, and welcome to the latest episode of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus, among other things, on helping businesses and their owners re-domesticate out of volatile legal and tax environments to predictable pro-entrepreneurship, pro-growth states like Florida and Texas. Today, we are discussing the single most important document in a redomestication. That is the plan of conversion. I will explain why any business owner who attempts to handle a redomestication on their own without a plan of conversion and without the advice of competent legal counsel is making a grave mistake that can potentially expose them to personal bankruptcy. That is not an exaggeration. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Every redomestication depends, among other things, on a single document that most business owners have never heard of. That's because they didn't go to law school. That is called the plan of conversion. Without it, the legal filings you submit to the Secretary of State may have no effect. Now, as a business owner, you know your business. You know it in and out. But if you are attempting to move your company from an existing state of domicile to a new state of domicile, that is like practicing brain surgery on yourself without going to medical school, not an embellishment. Without a plan of conversion, the legal filings you submit to the Secretary of State may have no effect or may have unpredictable effects. With it, your company transfers from one state to another, keeping its existing federal employer identification number, contracts, credit history, and bank accounts intact. The plan of conversion is not optional. It's not a check the box exercise. It's not a formality. It is the legal instrument that makes the entire redomestication work, and it is the document that most online filing services and even many attorneys leave out, or they may not even realize it exists. Here's what a plan of conversion does. And remember, this is just one document in a package of documents required for an effective and timely redomestication. The plan of conversion, among other things, identifies the redomesticating entity by name, jurisdiction, and entity type. It specifies the destination state. Okay, that's not rocket science. Here's where it gets complicated. It establishes how the ownership interests in the company will be treated and continued after the redomestication. It confirms, and this is important, that the existing contracts, obligations, assets, liabilities, bank accounts, and federal tax elections, including the Subchapter S election, if one is indeed in effect, of the company, carry forward with full force and effect. It sets forth the terms under which the redomestication is authorized and the conditions that must be satisfied before it becomes effective. Think of it as the constitution of the transaction. Every other document filed or prepared in redomestication, including by way of illustration and not exclusion, the certificate of formation, the certificate of conversion, and the statement of conversion in the prior jurisdiction, the board meeting minutes, or unanimous written consent. All of these derive their legal authority from the plan of conversion. If the plan does not exist, those filings may be moot or may have serious, unintended, and in some cases, irreversible consequences. The laws of both the origin state and the destination state require the adoption of a plan of conversion as a prerequisite to filing. This is not a guideline, it is a statutory requirement. You must have a plan of conversion before you file anything with the Secretary of State. Filing articles of organization or conversion or domestication, and by the way, terminology varies expansively by jurisdiction. Filing any of these documents without first adopting an attorney-prepared plan of conversion is, in many jurisdictions, a violation of law. I'm not kidding. In Florida, knowingly filing a false or misleading document, let me say that again. In Florida, knowingly filing a false or misleading document with the Department of State Division of Corporations is a third-degree felony under Chapter 817 of the Florida statutes. In Texas, filing a document the filer knows to be materially false is a Class A misdemeanor under the Texas Business Organizations Code, and that is elevated to a felony if the intent is to harm or defraud. The plan of conversion is also what preserves the non-taxable character of redomestication under the Federal Internal Revenue Code and applicable Treasury regulations. Redomestication is recognized by the Federal Internal Revenue Service as a non-taxable event. The treatment, though, depends on strict compliance with all statutory requirements, including the preparation and adoption of a proper plan of conversion. Without it, the IRS may treat the transaction as a taxable event, meaning the company and its owners may owe federal income taxes on a transaction that was supposed to have been tax-free, all because the owner was trying to save a few bucks and handle it themselves, or worse, they relied on incomplete or misleading advice from their attorney or CPA. The plan of conversion is the document that connects the state-level filings to the federal tax treatment. Remove it, and the whole thing falls apart. Now, a plan of conversion is not a template. You will not find one on the Secretary of State website. You may find templates for certificates of formation. You will not find a template for the plan of conversion, the unanimous written consent adopting that specific plan of conversion, or the statement of conversion filed with the former state, because those are custom legal documents that LegalZoom and Rocket Lawyer cannot prepare for you because they are not attorneys, nor are they law firms, and it is illegal to practice law without a license. Any template you do find on the internet will be at best incomplete and at worst the instrument that terminates your company. Termination, as I've covered in earlier videos, is not a good thing. The plan of conversion is the document that online filing services, as I said earlier, cannot prepare because that constitutes the unauthorized practice of law. They cannot render legal advice about its contents. By the way, neither can your CPA unless he or she is also an attorney. I'm not knocking CPAs, I'm also a CPA. They cannot tell you what happens if the plan of conversion is omitted because they do not know, in many cases, that the plan of conversion is required. Now, what these services attempt to handle is, in many cases, not a redomestication, but more often they are trying to sell you on the range of services they do offer, like a foreign registration, which is not the same thing as redomestication. When these services do attempt to handle a redomestication, they often file the certificate of formation and sometimes the certificate of conversion, but they skip the plan of conversion. And in many cases, they omit the filing with the former state. Now, the result is a defective transaction that may leave the company in a state of legal limbo, expose the owners to unlimited personal liability, and jeopardize the tax-free treatment of the transaction. Fixing these failures routinely exceeds $15,000 or $20,000, and in some cases, the damage cannot be reversed. At my law firm, when I handle a redomestication, I personally prepare a legal plan of conversion for every engagement, among other documents, and every document is drafted, reviewed, and filed by me, a licensed attorney and CPA. Not an overseas virtual assistant, not a paralegal, not an intern, me. I've handled hundreds of these redomestications with a 100% rate of success to date, not 99.9, a true 100% success rate to date. The process for almost every client is flat fee. The plan of conversion is, to recap, the document that separates a lawful redomestication from a filing that may terminate your company. Do not file anything without one. You will regret it. That's not a threat. That is a firsthand observation from having helped countless business owners who thought they knew the law and could just fill out a few forms on their website. Famous last words. If you have questions regarding redomesticating your existing LLC or corporation, please use the link in the description for more information on this legal process and to schedule time for you and I to speak one-on-one about your specific situation. Again, my name is Chad Cummings, and I hope that you found this information helpful, not condescending. I have to be direct. Every attorney owes clients and prospective clients the duty of candor, meaning a lot of my work involves telling people things they don't necessarily want to hear, and I cannot sugarcoat it. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Now, should you have any questions regarding this information or the content of any of my many earlier presentations on these sometimes overwhelming topics, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak and perhaps even work with you very soon.